So you walked into that courtroom and the temperature dropped 10 degrees. Not because of the air conditioning, but because of you. Every lawyer on the opposing side felt it in their chest like a warning bell they couldn't silence. You didn't strut or perform. You simply existed in that space as if you owned the deed to the building, and something in their survival instinct began screaming, "Retreat! Retreat!" But they couldn't, already locked in, already committed to a battle they'd actually lost the moment you filed your response. They expected an easy payday, another inheritance dispute, another grieving family member to bully into submission with legal jargon and procedural intimidation. Their briefcases were full of motions, their paralegals loaded with precedents, and their confidence inflated by 100 previous victories against people who didn't know the system. You, however, studied that system like a language designed for your fluency. You didn't just learn the law, you learned how lawyers think, how they move, where they hide weakness behind Latin phrases and courtroom etiquette. When the judge called the court to order, you didn't flinch. You didn't shuffle papers, clear your throat, or adjust your collar. You sat with the stillness of someone who had already won and was simply waiting for everyone else to catch up. The opposing counsel kept glancing at you, trying to read you, searching for the crack in your armor. But there was no armor. You were the weapon itself, forged by research, sharpened by righteous anger, wielded with surgical precision. They came for a plaintiff. What they got was a prosecutor with a personal vendetta and a legal education they didn't see coming. When the lead attorney rose for their opening, they gave the performance. Rehearsed gestures, calculated pauses, the sympathy play for the jury. You let them talk. You let them build their castle of lies brick by brick because you had the blueprint, the knowledge of every structural flaw, every foundation built on assumption instead of fact. 6 months earlier, while they celebrated strategy over expensive lunches, you were in real archives, not Google searches or ChatGPT prompts. You were pulling dusty county records from 1987, calling distant relatives they'd forgotten, cross-referencing bank statements with property records, tax filings, and the handwritten notes your grandmother left in the margins of her address book. You became a forensic accountant, a private investigator, and a legal scholar all rolled into one obsessed force of nature. They had 3 lawyers on retainer. You had rage and a library card, and somehow you outworked them all. Every night while they slept, you read case law. Every weekend while they golfed, you interviewed witnesses they didn't know existed. You learned terms like testamentary capacity and undue influence, not from law school, but from pure necessity. You taught yourself to file motions, submit evidence, and structure arguments judges actually respect. You studied their past cases, found their patterns, and identified their favorite tricks. In that process, you discovered something beautiful. The law isn't magic, it's a system, and systems can be learned, exploited, and dominated by anyone willing to put in the work. Those expensive schools gave them debt and connections. The public library gave you knowledge they couldn't buy. You understood what they'd forgotten in their comfortable careers. Desperation creates focus. Injustice creates motivation. And the combination becomes an unstoppable force expensive suits can't prepare for. When you finally filed your response, it wasn't just a reply. It was a declaration of war written in the legal code they thought belonged to them. And 47 pages, single-spaced. Every claim they made was systematically dismantled. Every assumption they built their case on exposed as fiction. And every witness they planned to call preemptively discredited with evidence they never knew you possessed. When their lead attorney read your response, he called an emergency meeting that lasted 4 hours. They realized they weren't facing an amateur. They were up against someone who cared more about truth than they ever cared about billable hours. By day 3 of the trial, they brought in their star witness, the executor of the estate, the one who claimed your relative was mentally incompetent when they changed their will. They painted themselves as a protector of the elderly, a savior preventing manipulation. You watched silently, taking notes as the direct examiner built the witness up like a pillar of credibility. And then it was your turn. The air changed. You didn't ask for permission to approach the stand or offer a polite smile. You walked up like a predator emerging from the tall grass, ready to strike. Your first statement wasn't even a question. You testified that you visited my grandmother every week for the last 2 years of her life, correct? The witness nodded confidently. That's interesting, you continued, because according to her phone records, the security footage from her building, and testimony from her daily caregiver, you visited exactly 4 times in those 2 years. Would you like to revise your statement, or should we continue with you under oath? The color drained from their face. The opposing lawyer tried to object, but the judge overruled. You pulled out a folder. Let's talk about the medication you claim she was taking, the one that supposedly affected her judgment. You said she was on high doses of painkillers that made her confused. You slid a document across the table. This is her complete medical record, signed by her physician. She was taking low-dose aspirin and a multivitamin. No painkillers, no sedatives, nothing that affects cognitive function. So are you mistaken about basic medical facts, or are you lying? The witness stammered, backtracked, tried to claim confusion about dates. You leaned in. That's fascinating, because you provided a sworn affidavit with specific dates and times claiming you witnessed her confusion. Were you confused when you signed that legal document under penalty of perjury? Objections flew. The judge banged the gavel, but the damage was done. The jury saw the truth. The witness was crumbling. Every word they spoke unraveled 3 more contradictions. For 45 relentless minutes, you dismantled every piece of their story. You presented bank records showing unauthorized withdrawals, emails proving their knowledge of the fraud, recordings from nursing staff describing your grandmother's sharp mind until the very end, and a handwritten letter authenticated by experts, where she explained exactly why she changed her will, and specifically named that witness as untrustworthy. When you finally said no further questions, the witness looked like they wanted to crawl under the table. The opposing attorney didn't even attempt to redirect. There was nothing left to salvage. But that devastating cross-examination wasn't even your final blow. You had saved the nuclear option for closing arguments. While they obsessed over the inheritance dispute, you were quietly building a parallel case they never saw coming. You had filed motions alleging fraud, elder abuse, and breach of fiduciary duty, civil and criminal. You weren't just after a verdict. You wanted justice that echoed beyond the courtroom walls. When you stood for your closing argument, you didn't need notes. You looked directly at the jury, your voice steady, filled with certainty. This case, you said, was never about money. It's about respect. Respect for a woman who worked her entire life, saved every penny, and made clear choices about who she trusted and who she didn't. Then you paused, glanced at your wristwatch, and let the silence say the rest. The opposing side wanted the jury to believe your grandmother was confused. You stood tall and said, "Let me show you what confusion actually looks like." Then you pulled out their own filings. In their initial complaint, they claimed the will was changed in June. In their amended complaint, they said August. In their witness testimony just yesterday, they said September. That wasn't evidence. It was improvisation. You walked the jury through a timeline so precise, so documented, and so irrefutable that even the judge leaned forward taking notes. You showed them the paper trail, the witnesses, the expert testimony, and the video footage of your grandmother, recorded 6 months before her passing, clearly explaining her wishes in her own words. You presented the signature analysis proving the contested will was completely legitimate. You revealed financial records proving the executor had already begun spending inheritance money before she was even gone. And then, with a calm, unwavering voice, you delivered the line that made 2 of their lawyers quietly pack up their briefcases mid-trial. Your Honor, members of the jury, you said, I'm not just asking you to rule in my favor. I'm asking you to send a message that elder abuse will not be tolerated, that fraud has consequences, and that you cannot gaslight a grieving family and expect to get away with it just because you hired expensive lawyers. These people thought they could use the legal system as a weapon. I'm here to remind them that the legal system is a shield for the truth. You paused. The silence was electric. And the truth, you continued, is sitting right here in these documents. The truth is in my grandmother's own words, and the truth is about to cost them everything they tried to steal. After your closing argument during the lunch break, something unprecedented happened. The lead attorney from the opposing side approached the judge and requested a sidebar. You watched as they exchanged a hushed, tense conversation. The judge's eyebrows rose, then furrowed before glancing at you with something between respect and disbelief. When they returned to the courtroom, the lead attorney made an announcement. Your Honor, we'd like to request a continuance to discuss settlement options with our clients. Translation. We're getting destroyed and need to stop the bleeding before this gets worse. But you weren't interested in settlement, not anymore. You stood up and said firmly, Your Honor, the plaintiff objects to any continuance. We've been ready for trial for 6 months. The defense has had ample time to prepare. If they're unprepared now, that's a strategic failure, not grounds for delay. The judge nodded in agreement. The trial would proceed. That's when the second defense lawyer stood up, apologized to the judge, and abruptly quit, citing irreconcilable differences with case strategy. Translation: I'm not going down with this ship. By the next morning, only one lawyer remained, the lead attorney, pale and exhausted, clearly running on no sleep. He made a motion to dismiss their counterclaims, withdrew half their witness list, and effectively surrendered everything except the technicalities. But you didn't let up. You called your final witnesses, a psychiatrist who confirmed your grandmother had full cognitive function, a financial advisor who detailed exactly how the executor had been siphoning funds, and a neighbor who testified about the manipulation attempts to pressure your grandmother into changing her will. By day 6, the defense rested. They had no more witnesses, no more arguments, and no more confidence. Their entire strategy had collapsed right in front of everyone, and all you had done was tell the truth, backed by evidence they never imagined you could uncover. The defense's closing argument felt less like strategy and more like surrender. The last remaining lawyer stood there, shoulders heavy, his voice trembling as he addressed the jury. Ladies and gentlemen, he began, emotions have clearly run high in this case. Mistakes were made, perhaps even serious ones, but let's not destroy reputations and lives over a misunderstanding. You almost laughed out loud at the word misunderstanding. They had tried to steal a 6-figure inheritance, gaslight an entire family, and forge evidence to cover it up, then had the nerve to call it a misunderstanding. The courtroom air was thick with disbelief. The jurors, the reporters, even the bailiff, all of them knew that what they had witnessed wasn't confusion. It was premeditated deception unraveling under the weight of truth. When the jury retired to deliberate, there was no tension, no uncertainty in your gut. You already knew how this would end. 90 minutes later, barely enough time for them to finish their sandwiches, they returned. The foreman stood, verdict slip in hand, eyes steady. The courtroom fell silent. We, the jury, find in favor of the plaintiff on all counts. The words rippled through the room like an earthquake. All counts. Not guilty on every one of their fabricated claims. Full inheritance restored to you. But that wasn't even the best part. The jury had gone beyond what anyone expected. They awarded punitive damages, large enough to send a message to anyone who might try such fraud again. They included attorney's fees even though you had represented yourself, a decision so rare it would later be quoted in legal textbooks. They even recommended a criminal investigation into the executor's conduct, stating that the evidence presented warranted further scrutiny by law enforcement. And then came the moment that made the case immortal. The jury foreman had added a note to the written verdict, one the judge read aloud with clear admiration in his tone. The court recognizes the extraordinary preparation, courage, and legal acumen demonstrated by the plaintiff in this case. This was a masterclass in self-representation, and a cautionary tale about underestimating someone's commitment to truth and justice. For a long, almost sacred silence, no one moved. The remaining defense lawyer sat frozen, his eyes glassy with disbelief while the jurors exchanged looks of quiet respect. The once arrogant executive, the person who'd tried to rewrite your family's story for profit, was escorted out by investigators who had been watching the trial from the gallery at your request. The irony was poetic, the hunter dragged away by the very system they thought they controlled. You didn't speak, you didn't celebrate. You just breathed, slowly, deeply, feeling the immense stillness of victory. This wasn't just about money anymore. It was about validation, about rewriting your own place within a system designed to silence those without power. You had entered a courtroom built to favor wealth and walked out with a verdict that favored truth. Every hour you'd spent in libraries, every sleepless night combing through documents, every late call to forgotten witnesses, it had all converged into this one undeniable moment. When the judge finally cleared the courtroom, he called you to the bench. His expression had softened, the stern authority replaced by something closer to admiration. "Off the record," he said, lowering his voice. "Where did you study law?" You smiled, unable to resist the truth. "The public library, Your Honor." And spite, mostly spite. He laughed, a real, unguarded laugh, the kind that only surfaces when respect transcends formality. "Well," he said, "you've just done what most licensed attorneys can't. You proved that the law isn't owned by institutions. It belongs to anyone willing to learn it." You nodded, and he leaned in with a quiet warning. "Be careful. You've made a lot of enemies in this field today. Lawyers don't like being shown up." You gathered your folders, still warm from the courtroom lights. "Good," you said evenly. "Let them be afraid. Let them know people are waking up, learning their tactics, speaking their language. We're not intimidated anymore." The judge's faint smile was the last thing you saw before you stepped into the hallway, where reporters waited with flashing cameras and buzzing microphones. You walked out of that courthouse not just with your inheritance and your dignity, but with something infinitely greater, proof that the system could be beaten by someone who refused to surrender. The media picked up the story before sunset. Legal blogs ran headlines like "Self-Taught Litigant Shocks Courtroom" and "David versus Goliath." The case that changed everything. Commentators called it one of the most significant self-representation victories of the decade. Law students across the country began requesting the court transcripts to study your cross-examination techniques. Professors cited your case as an example of procedural precision and moral tenacity. Within weeks, your email inbox was overflowing. Families across the country, people facing inheritance fraud, predatory contracts, and legal manipulation, were reaching out. They wanted to learn what you'd done, how you'd done it, and how they could defend themselves in a system that often seemed rigged against them. You realized something profound in that moment. This victory wasn't the end. It was the beginning of a new mission. You remembered the judge's question, "What are you going to do now?" You already knew the answer. "I'm going to help others do exactly what I just did," you told him. "Because if I could learn this system, anyone can. And there are too many families being robbed by people who think expensive lawyers make them untouchable." The judge had nodded slowly, his eyes distant but thoughtful. "Then be ready," he'd said. Because change always scares those who profit from chaos. Now, as you stood outside the courthouse with the verdict still echoing in your ears, you felt something shift inside you. The fight was no longer personal. It was collective. You had uncovered a truth most people never realize. The law isn't magic, it's structure. And structure can be studied, mastered, and wielded by anyone with the will to learn. And that realization made you more dangerous than any attorney with a corporate retainer. You walked away not just as a victor, but as a symbol, an untrained, underestimated force who had proven that justice isn't sold to the highest bidder. It belongs to those who refuse to quit. You had become something the legal establishment never wanted to exist. A competent pro se litigant who didn't just survive the system, but completely outclassed it. You weren't a one-time anomaly or a lucky exception. You were a living, undeniable blueprint. Proof that ordinary people armed with patience, intelligence, and relentless willpower could stand against million-dollar law firms and win. And that, more than anything, made you dangerous. Because if one person could decode the system and use it with precision, others could too. You had shattered the illusion that the law was an elite language reserved only for those who could afford the tuition, the suits, or the secret handshakes. You had turned knowledge into rebellion. The ripples of your victory spread fast. The lawyers who quit mid-trial never recovered professionally. One resigned from the firm entirely. Rumor has it they couldn't handle the humiliation of being publicly dismantled by someone with no legal background. The second retreated into obscurity, no longer taking high-profile cases, choosing instead to quietly draft contracts in a dim corner office, haunted by the ghost of that trial. Within legal circles, your name became a whisper. The civilian who destroyed a firm's reputation. Meanwhile, the once respected executive, the person who tried to twist your family's grief into profit, found their life unraveling piece by piece. Investigations opened for elder financial abuse, perjury, and fraud. Bank accounts were frozen, statements subpoenaed, and former allies turned witnesses overnight. The empire they built on deceit was collapsing, one ethical violation at a time. The case became a benchmark in law schools and media circles alike. Professors analyzed your filings as examples of clarity and logic. Journalists called it the trial that humbled the system. Commentators debated whether you had exposed a deeper truth about the justice system itself, that it was never truly about expertise, but access. That the difference between helplessness and power was knowledge, and you had proved that anyone willing to learn could wield it. Law students began citing your cross-examination in online forums, legal blogs titled "Articles After You." It was no longer just a courtroom win, it was cultural disruption. But for you, it was more personal. You remembered the moment they offered you that settlement, 60% of the inheritance. Their smiles were professional, their tone condescending. "We just want closure," they said, hoping money could silence principle. But you knew what they didn't. This fight was never about numbers in a bank account. It was about truth. It was about the principle that no family should be bullied, no legacy rewritten, no elder exploited simply because the perpetrators believed their lawyers were smarter. You turned down the offer without hesitation, fully aware that you were walking into war, but also knowing that sometimes a message is worth more than a check. And that message echoed louder than anyone expected. The era of intimidation is ending. For decades, legal power relied on a carefully guarded secret, the illusion that the system was too complex for ordinary people to navigate. You had dismantled that illusion in one public trial. You exposed the truth, that the law, at its core, is public information. That everything they try to hide behind paywalls and Latin phrases already belongs to the people. You proved that complexity isn't a sign of intelligence. It's a business model. Complexity keeps clients dependent, keeps invoices flowing. But justice, Justice is simple. Truth is simple. And you had both on your side. Soon, your phone began ringing. Emails poured in. People from across the country reached out. Widows being gaslit by estate managers. Siblings locked out of inheritances. Children facing manipulative trustees. They all said the same thing. I saw your case. Can you help me? They weren't looking for free legal advice. They were looking for hope. They wanted to believe that the system wasn't invincible, and you told them what no attorney ever had the courage to admit. You can do this. The law belongs to you. The information is public. The procedures are written down. Everything you need is already out there. You just have to work for it. You told them that what the legal industry fears most isn't competition, it's comprehension. Because once people understand the rules, the power imbalance dissolves. Once citizens start reading what lawyers read, filing what lawyers file, and thinking the way lawyers think, the monopoly of fear is broken forever. And you began teaching others to do the same. You showed them how to request documents, how to read case law, how to prepare evidence, and how to argue without emotion clouding their strategy. You transformed your rage into a curriculum. Your grief became a movement. Soon, forums dedicated to self-representation started referencing your case. You were invited to speak at advocacy groups, asked to share your journey with families who'd been wronged. People who once felt powerless began walking into courthouses with newfound confidence. Some even started winning. The ripple effect of your defiance was turning into a wave of public empowerment. The money you won became secondary, almost irrelevant. Yes, it secured your family's future, but it also financed something far greater. You built a small foundation dedicated to educating people about their rights. You hosted free online sessions breaking down how to navigate probate law, how to identify fraud, how to file motions without fear. You reminded everyone who listened, the law is not sacred, it's logical, it's learnable, it's yours. The real victory wasn't on the verdict form, it was in your transformation. You had proven to yourself that you were never helpless, that systems designed to exclude you could be studied, understood, and beaten. You became living proof that intelligence, preparation, and moral conviction matter far more than credentials, connections, or courtroom theatrics. You had walked into that courthouse broken by grief and burning with anger. But you walked out something entirely different, refined, awakened, unstoppable. You didn't just win a case, you shifted an entire paradigm. You reminded the world that justice was never meant to be gated behind degrees or prestige. And as you stood outside the courthouse for the last time, the cameras flashing, your reflection caught in the glass doors behind you, you realized what you'd truly done. You had cracked the code of control. You had turned pain into purpose, rage into reform, and knowledge into power. You were no longer just the person who won their inheritance case. You were a living warning to an industry built on arrogance, proof that the playing field isn't tilted toward the powerful anymore. Because now, the people are learning. And once the people learn, they don't forget. You walked out of that courthouse as someone entirely reborn, someone who had taken pain and sculpted it into power, turned loss into legacy, and transformed injustice into a case study that would echo through legal halls for decades to come. What began as a personal battle had become a cultural shift, a testament to human resilience and intellect. Your name had quietly entered law journals, ethics symposiums, and university lectures, not as a lawyer, but as something more dangerous, a citizen who refused to stay powerless. Every time a law student reads about your case, they don't just study legal precedent, they study courage. They learn that the system isn't invincible, that its walls are only as strong as people's ignorance of them. Every time a family decides to fight back against estate fraud, they're unknowingly building on the foundation you laid. Every time a corporate attorney hesitates before dismissing a pro se litigant, They remember what happened when someone like you walked into a courtroom alone and won. You didn't just win a case. You shifted the atmosphere around what victory even means in a courtroom. You replaced arrogance with apprehension. You replaced dismissal with respect. You changed the narrative from impossible to inevitable. The opposing counsel learned the lesson the hard way, one they'll carry through the rest of their careers. That preparation will always beat pedigree. That truth will always outlast tactics. And that someone fighting for love, justice, and family will outwork someone fighting for billable hours every single time. They came expecting to crush an emotional, grieving relative, someone blinded by heartbreak and naivete. Instead, they met a strategist, a scholar forged by grief, a warrior sharpened by injustice. You had spent 6 relentless months studying inheritance law with the precision of a specialist and the hunger of a survivor. You absorbed information like oxygen, reading until your eyes ached, analyzing every statute, every precedent, every loophole they could possibly use. And then you used it against them. It cost them everything: their confidence, their composure, and eventually, their case. Your grandmother would have been proud, not just because you won, but because you proved her faith in you was justified. She had seen what others overlooked. She knew who in the family she could trust, and who circled like vultures when the scent of money filled the air. She saw through the false kindness, the manipulative concern, the polished lies. When she changed her will, she wasn't confused. She was crystal clear. She knew exactly what she was doing, and you honored that clarity. You honored her not with flowers that would wilt, not with tears that would fade, but with something eternal: justice. You turned her wishes into reality, her truth into precedent, and her memory into something no court could erase. You didn't just make sure her words were respected, you amplified them. You made sure her truth was not buried beneath forged documents and false testimony. You made sure that those who exploited her kindness faced accountability in the same system they once used to intimidate others. You didn't settle, didn't bend, didn't break. You refused every compromise, every friendly offer designed to silence the truth, because you weren't seeking comfort. You were seeking correction. You weren't fighting for revenge. You were fighting for restoration. And when the gavel struck for the last time, it didn't just mark the end of a trial. It marked the beginning of a new standard. Your victory became the story every ambitious attorney had to acknowledge, the case every legal ethics professor referenced when teaching about self-representation. Your persistence forced the system to look at itself in the mirror, and it didn't like what it saw. Because the truth was undeniable, you had accomplished what generations were told was impossible. You had walked into a courtroom built to favor wealth and walked out proving that intellect, heart, and preparation can dismantle power structures more effectively than any law firm. Reporters wrote about your calm demeanor, your surgical questioning, your ability to turn evidence into narrative. But what they couldn't capture was the deeper transformation, how grief had purified your purpose. You had entered the fight broken, questioning your strength, unsure if you could face giants in their own arena. Yet by the end, you were something far greater than even you imagined. Not a litigant, not a reformer, but a symbol of what happens when the human spirit refuses to yield. You left the courthouse that day not just with your inheritance, but with a legacy that would ripple across generations. Your story became the North Star for every underdog, every self-taught warrior, every soul who ever felt powerless against bureaucracy. It became the whispered encouragement for the next person standing where you once stood, alone, terrified but determined. And perhaps the most powerful part of it all was this: you didn't just fight for your grandmother's will, you embodied it. You became her living testament, her strength, her integrity, her unshakable sense of right. She had passed down more than assets. She had passed down courage. And you proved that inheritance doesn't always come in money. Sometimes it comes in the form of fire, the kind that burns through lies and lights the way for others. You walked out not just as someone who won, but as someone who rewrote what winning means. You were no longer just a name on a legal document. You were a force, a precedent, a reminder that when love, intellect, and justice align, no system, no institution, and no opponent stands a chance. That's all for today. Dear Father, I pray for the growth of my faith. Help me trust you even when physical evidence is lacking. Let me believe in your perpetual presence, knowing you will never harm me. I understand that your thoughts for me are thoughts of prosperity and not harm, to give me a good future. Thank you, gracious and eternal Father, for always listening to my voice. I offer up this prayer to you in the name of Jesus. Amen. Thank you, Jesus, for your love and provision. I am grateful for your presence in my life and the abundance you bring. If this video resonated with you, please like, subscribe to the channel, and share it with those who need to hear this message. Leave a comment below about your journey and how you are preparing for your own triumphant return. If you'd like to support our work, please consider contributing through Buy Me a Coffee. This helps us continually improve our content to offer you the best. The link to Buy Me a Coffee is in the description. No gift is too small. Whether it's a penny, a prayer, or a share, your generosity helps spread God's word and brings hope to others. Don't stop here. Watch our next video for powerful revelations about the signs that reveal you are the chosen one. We've enjoyed following this spiritual journey with you. Thank you for staying with us until the end. Keep shining brightly and embrace your destiny with courage. See you next time. Blessings to all the beautiful souls from the Enlighten Wisdom.